Hello and welcome to Compliance Talk. I'm Michele Shuster.
And I'm Chad Blackham.
And today we have a lot of really interesting topics to talk about, starting with something really crazy out of Tennessee this month. The Tennessee House has passed a bill that, if enacted, would limit the amount of telephone solicitation calls that could be made using an automated telephone system to 10,000 per month, which is not a lot when you're talking about the telemarketing industry. It would also require that any company that makes more than 500 calls per month would have to file a report with the Tennessee Public Utilities Commission. And there's a presumption that any calls over those amounts would be an unfair, deceptive act or practice. So this is significant. It's only passed the House, so it remains to be seen if it'll get through the Senate and if the governor will sign it. But something definitely to track. Have on your radar, and if you live in Tennessee, this would be a great time to reach out to your state congressional members.
Absolutely, and that 10,000 call threshold really is pretty low, especially in the space. I feel like I get that many alone by myself some months. But switching gears a little bit to the federal level, after we talk about some of these state requirements, the FTC has started up some new enforcement actions relating to kind of an old favorite of mine, the Made in America standard. Now, as a lot of you might be aware, the Made in America standard, or Made in USA, imposes certain regulatory requirements on businesses who claim that their products are manufactured, produced, or otherwise constituted or reconstituted in the United States. It's kind of been a smaller regulation. It hasn't been enforced too much in the past, but the current FTC has come forward with 3 brand new enforcement actions relating to claims in what they claim is an effort to protect consumers and businesses from these deceptive trade practices. Now, I'm not going to go into all of these in detail. They relate to various industries such as flags, flagpoles, tents, things bearing the American flag and emblem, and some of the claims these companies were making. But what is really notable here is that the FTC is showing a willingness and an eagerness, in my opinion, to enforce some of its less often prescribed, less often known regulations, many that some people may have fallen by the wayside in recent years. So as we look at these enforcement actions regarding the Made in USA standard, I think it's also important to look at how this could be extrapolated to other areas and how the FTC may use less often known laws to try and enforce things in a new way or in a new light. And we saw that actually a couple weeks back in our Compliance Talk discussion regarding some of the privacy bills and how those have been having interactions with old wiretap laws. So the FTC seems to be on that train as well, and this Made in the USA standard might be an indicator that we'll be seeing some older regulations brought back for a new purpose.
Yeah, the FTC has been very busy lately, which I know they lost a lot of personnel within the last year and a half. So really interesting to see how active they continue to be. So don't discount the FTC and their willingness to initiate enforcement actions. I'm going to switch a little bit from the FTC over to the FCC, who has been equally, if not more, busy with their notices of rulemaking and also enforcement action. So we'll start with an enforcement action, which is a show cause order that went out to a company by the name of SK Telecom, which apparently is an AI teleservices providing company. And there are a number of things here that are really cautionary tales for companies to make sure they don't do. And so specifically, this company was required to file a robocall mitigation plan in the robocall mitigation database. Anybody who's done that knows that you are required to provide contact information for a company representative. And the thing I would tell you is that email address should accept emails from the Federal Communications Commission. In this case, there was some automatic blocking that occurred. And so the company was definitely behind the 8 ball in that they did not respond quick enough to notices from the FCC. And those notices specifically had to do with, again, a failure to respond to something, and that was the industry traceback group requests for information on. It was about 20 calls, I believe, that they were seeking traceback information on. They did not respond timely. And so the FCC has issued a show cause order. They have given the company some additional time to respond, but just those cautionary tales that make sure that any information you're providing to a regulator about how to contact you is actually going to allow that regulator to get through. And then whenever you have an industry traceback request, those are required to be answered within 24 hours. So that's not just that, hey, we'll get back to you. That is that you have to provide some type of substantive response to those. I can tell you the FCC is following those very closely, as are the state AGs. The other thing that we have going on with the FCC is that they have filed a notice of proposed rulemaking that has to do with offshore call centers. They had signaled that they were going to do this last month, and that hit the Federal Register this week. And so if you are using offshore call centers, you really need to pay attention to this because this would be very limiting and is going to cause substantial operational disruption if it goes into effect and if you are not prepared. Some of the things that they are contemplating is limiting the number of calls that can be sent to a foreign call center, giving the called party the absolute right to request that that telephone call be transferred to a U.S. call center. They're mandating that there would be proficiency training in American Standard English, so additional training that would be required to occur. So lots in here to digest. If you haven't looked at it yet and you're using foreign call centers, really highly recommend that you take a look at that and that you consider filing a comment. Comments are due, I believe it's May 26th, so you have time to do that. We're always obviously happy to help companies that are interested in filing those types of comments.
Absolutely. And to wrap things up, we've got one last thing from the federal government. So if you recall, during our last compliance talk, we discussed a little bit about the federal AI framework that the federal government was looking to institute and kind of the interaction that was going to have with some of the state laws that were upcoming. Most notably, the federal government had expressed an intent to preempt state laws, meaning that there would be a federal coverage with no conflicting state laws underneath. The feds would reign supreme in the area. Well, we have our first update in that area only a couple weeks later, and it relates to the most onerous state-level artificial intelligence law from Colorado. So Colorado has an Artificial Intelligence Act, aptly named the AI Act, set to go into effect on June 30th of this year. It would impose a lot of burdensome restrictions, particularly on employers. Just by way of brief example, you would have to have risk management programs, you would need annual reviews, quarterly audits, you would have to have disclosures regarding algorithmic discriminations and decision making. It's very, very burdensome, and by my token and account and review, the most burdensome one currently on proposal in the country. Well, or at least it may have been, because the feds, in a case challenging the validity of the law and the constitutionality of the law, the Department of Justice has filed a supplementary briefing arguing that the law is unconstitutional under the 14th Amendment's Equal Protection Clause. And if you want to look at the briefing a little bit more, they go on to describe how they believe that some of the algorithmic discrimination could impact people disparately in violation of the amendment. But I think it's a very fascinating novel argument, and what's really significant is it evidences the first solid example we have of the federal government trying to really take advantage of the framework that it proposed and exert that federal supremacy over the state AI laws. So the first of many, I'm sure, to come, and we'll be watching this one very closely as an instruction towards others and also to see what happens next. But I believe that's all we had today. Thank you all very much for joining, and we hope to see you on the next Compliance Talk.